What happens if it's one person's word against the other? Imagine this. You've had a consensual sexual encounter with someone, and a week later, or a month later, or several years later, they make an accusation that that encounter was not consensual. What do you do to prove your innocence? What a scary position it is, and I've represented a number of people who have been accused of things that they said they did not do. And it becomes sometimes a he said, she said, or a he said, or a she said, she said. But it's one person's word against the other. Sometimes, as we know, there are cases where there are witnesses that are involved. They see something, they become witnesses, and they can testify to what they see or hear. However, there are some cases, and some of those cases even get charged out, where it is simply one accuser versus someone who's saying, I did not do this, this is a false accusation. And that's a scary situation to be in, especially if an amount of time has passed and you may begin to wonder, how can I prove my innocence? And if we're dealing with a sexual assault claim, it can be even more intimidating perhaps, because there's a certain body of the public that, while they may say prove it in some other kinds of cases, or they may be willing to extend the presumption of innocence in other types of cases, if it's a theft, if it's a homicide, if it's who ran a red light and crashed in an accident, and whose fault is it? Someone says, I had the green light, the other person said, no, I had the green light. People may be willing to extend the presumption of innocence to whoever's accused in those sorts of situations. But sometimes in a climate that we're in with allegations of sexual assault, some people aren't willing to extend that same presumption of innocence. And that's, among other things, what jury selection is for. So what happens when it's a he said, she said? Well, in some instances, law enforcement may decide that they don't have enough to forward charges, or the prosecutors decide that they don't have enough probable cause to charge someone with a crime. But there are many cases where, despite it being one person saying it happened and the other person saying no, it didn't, that law enforcement or prosecutors will still charge those cases out. And we've got two different arenas we may be dealing with here if it's a sexual assault allegation. One arena is the criminal court, like if you're charged with a crime. And that's where constitutional protections apply. In the other arena might be a Title IX arena with colleges and universities. The good news is after August 14th of 2020, you get the presumption of innocence if you're accused, both in the criminal case and now in Title IX cases as well. The law has changed, so you are presumed innocent, whether it's a criminal case or a Title IX case. But that's where some of the similarities end. If it's a criminal case, the government has the burden of proof beyond a reasonable doubt. That means that the prosecutors have to prove your guilt beyond a reasonable doubt to a jury or a judge. If you decide you want a jury, you get a jury. And if it's a felony charge, you get 12 jurors, and all 12 jurors unanimously have to find you guilty beyond a reasonable doubt for you to be convicted. And so sometimes, look, the reality is lawyers don't always know if their client did this or not. There are cases where we figure it out later, but sometimes nobody knows if it really happened or not besides the person that's making the accusation and the person that's accused, because they may have been the only two people in the room. And that becomes a really difficult situation. But our American justice system, our Constitution, values the idea that we do not want people wrongfully convicted, and that is a greater wrong to imprison someone, even for a day, that was truly innocent, than it would be to find a guilty person not guilty. That's where our values lie. We err on the side of protecting the accused so that we can try to avoid wrongful convictions. And so in these cases, what comes down to oftentimes are alleged victim testimony, and then sometimes you've got a right to remain silent in a trial if you're accused of something, and you do not have to testify to defend yourself, and the jury will be instructed that they are not to use your silence against you. So you don't have to talk to the police, and you don't have to talk in your own trial. You don't have to testify and a jury is required to honor the idea that you don't have to testify. It doesn't mean you're guilty. There's a lot of reasons why someone may decide not to testify in a trial, even if they're fully innocent. So you have that right. And at the end of the day, the defense doesn't have to provide any evidence as well. So at the end of the day, what has to happen is the jury has to begin their analysis and say, all right, there's an accusation. We, the jury, are required to presume the defendant innocent. And it's the prosecution's job to prove that guilt beyond a reasonable doubt, which is the highest burden of proof in the land. It's the same burden of proof that there is in a murder case. Now, there are some criminal sexual conduct cases and murder cases and what have you where, despite that presumption of innocence and despite the burden of proof beyond a reasonable doubt, people can still be found guilty even in a he said, she said scenario. That can happen. But there are also protections built in place so that hopefully we as a society and a jury in a case don't get it wrong, because that's a scary thing. And the longer ago that an allegation was, the harder it may be, or you may feel if you're accused, wait a minute, they're saying 3 years ago now that we had intercourse, but that wasn't consensual, or that they were too drunk to consent, or whatever might happen like that. And you might wonder, how can I prove that? I mean, I can't even go back anymore and show cameras that show that we were both having a great time together when we walked in the apartment and we were holding hands and everything was romantic, and now the accuser's saying that I dragged them into their apartment and all these sorts of things, and you can't go back and find some of this evidence that would have been helpful to you to show that perhaps that the story isn't true, or the story leading up to the act isn't even true, which of course would cast doubt on the rest of the testimony. And that's one of the problems in these sorts of cases. But that's why at the end of the day, these protections are built in. So yes, you could still be found guilty, even if it's a he said, she said, or one person says it happened and one person didn't. And I hope I'm not offending anybody by using gender pronouns. I'm not trying to do that. But usually when we have a situation, if it's a criminal sexual conduct case, more often than not, the female is the accuser and the male is the accused, and that's just kind of normally how these cases go. There are, of course, exceptions, so I'm just using what is the general scenario. If we moved over to the Title IX arena, there's a different burden of proof right there. More often than not, universities, even now, after August 14th of 2020, with the new Title IX revisions, most universities that I'm aware of are using the preponderance of the evidence standard rather than the clear and convincing standard, which is a higher standard of proof. Meaning, universities are usually saying it just has to be proven by 51% or 50.1%. Just a little more likely than not is enough of the burden of proof in university settings in Title IX hearings, as opposed to criminal cases where the burden of proof is beyond a reasonable doubt. And there are other issues that you don't get the same due process protections in Title IX situations that you do in criminal court, but that's for another video. At the end of the day, if you don't testify, the jury has to look at it and go, is it proven? Because just because somebody says something happened doesn't mean it happened. We know there are cases where a rape has happened, whether it's a day ago, a week ago, a month ago, 10 years ago, and they're reported now, and it doesn't mean they didn't happen. They can happen. But there are also cases where somebody will make a false accusation for a whole bunch of reasons. They might have some motives to make a false accusation. And in those situations, you may be feeling like it's hopeless and that nobody's going to believe you. But understand, you're presumed innocent. It's the government's job to prove it beyond a reasonable doubt. What you want to do in these hard times, if you're going through that, lean on your family and friends. Lean on your supporters. Get a lawyer that has experience in handling these sorts of situations where they said you did it, you say you didn't, and how do you handle that situation if there's really not much more evidence than that? And how do we overcome some potential biases that some people may have in viewing these sorts of reports? Everybody's humans. Everybody comes into some situations with some biases. How do we deal with that so that you're going to get a fair process, and that the fact finder, whether that's just a judge or whether it's a jury, is going to be fair to you and really uphold that presumption of innocence and the burden of proof beyond a reasonable doubt? Finally, I want to give you a little hope. This is one wall I have in my office. It says the jury speaks right up at the top, and each one of these are not guilty verdicts in the background. And I put that up there to give you hope, because every one of these people were accused of something that they didn't do. And they felt when they came in, they didn't know what their world was going to look like a month from there, 6 months from there, a year or more from there. They potentially risked prison. They risked losing their jobs. They lost some friends over some accusations sometimes. And at the end of the day, what I remind them is we have to keep our eye on the ball, which is the end of the process. It's not going to be an easy process, but you got to know your truth. And there are ways that you can get through this day by day, and there are lawyers out there who are here to help you. And if you find that in a situation, I just want to give you peace that at the end of the day, it's a long process, but that justice can come out. It's not a perfect system. Unfortunately, sometimes people that are falsely accused are going to be found guilty. I wish I could change that for people, but that's not how our world works, and that's not how our justice system works. It is imperfect, just as there are guilty people who are sometimes found not guilty. Again, it's a human process, so it's never going to be perfect, but the more work we put into it, I think the better advocacy you have and the more experience of a lawyer you have someone that's really willing to listen to you and hear your side of the story, and then understand what it's like to be in your shoes, and take a look at the case from different angles and everything, and really do the work to turn over every stone. I think the higher likelihood you have of getting a true verdict in your case, and that's what I'm here to help with. If you have any questions, I'm criminal defense attorney Ryan Pacyga. You can call me at 612-339-5844. You can find me at arrestedmn.com, and I've got a support page up on Facebook for the falsely accused. You can check that out. I'll have a link below, and I hope that you find some good resources there, not only for you if you're falsely accused, but also for any family members or friends that want to help someone that they say, I know this person and this isn't in their character and I don't think they did this, and I want to be there for them. I hope you find that to be a helpful resource as well. Thank you.